Let your verdict give us the answer.
Ma'am, what actually made you decide to take up the law?
Well, I hadn't initially decided to get into the legal practice. I was more interested in teaching, and I did do a stint of teaching in Miranda House and Vivekanand, and then I got a job even with Garki College.
Right.
But I didn't go and teach eventually in Garki College. I taught in the earlier two colleges. Then I was in two minds as to whether to get into the government services, which was considered to be the most coveted career path, or whether to get into the profession. And at that point of time, after I finished my masters, I decided to do law in the evening, and that interested me. And I think even the background of my father being in the legal profession, my brother being a lawyer, I think that also would have had some kind of an impact on me.
Did family push you into the law? Did they suggest that you should possibly try this? No,
they didn't push me at all. They didn't push me at all. In fact, I was much more interested in academics. I moved, sometime when I was in my late 20s into the legal profession. I was teaching in the morning, and I did my law in the evening classes, and thereafter decided to take to law as a profession.
What did you do your graduation and your post-graduation in?
I did in political science.
Even your post-graduation?
Yeah, both.
Do you think that political science has helped you, grasping constitutional law, public law, things like that?
I think so. Basic concepts, etc. were taught. I think that did help as a background.
Well, how was the experience actually in teaching? Because I think one of the major issues that viewers will like to know about is about why we don't possibly have the best practical experience coming into legal academia, because many of them are either academics or don't really have the experience of the court system and things like that. And you were possibly teaching political science, and how was that experience? Would you possibly consider?
I think it was a very good experience, because it helps you articulate, it helps you, explain concepts to students. And I think it was a very good exposure. In fact, one of the eminent senior counsel today, I don't know if you all are aware, Mr. P.P. Rao, he was a regular teacher in Delhi University. He was a regular teacher in Delhi University, and then I think he represented Delhi University for many years. I think teaching certainly helps, and especially in the initial years when you're not so very busy, if you are able to devote some time, I think it certainly helps.
Right. Ma'am, whether anything as far as your experiences in school or college, your teachers or anybody that you'd like to recall or recollect who might have helped you, make up your mind about who you are?
I don't think there was any one single person, I would say. I think a person evolves and grows and goes through various vicissitudes of life. I wouldn't say any one individual person at that part during that part of my life. I think in the legal profession I learnt a lot from various eminent senior counsel. I was working in a counsel on records office for 3 years, and I got a lot of opportunity to work with the top seniors. I think every single eminent senior counsel in the country, I got a chance to interact with them, hold conferences, and I learnt a lot from them. That is where I feel was the main learning process in the legal profession, more than teachers and all in school and all, not really.
Right. Could you just spend a few minutes just telling us what it was like growing up, where you grew up, where the schooling was, how your family moved from? I understand you were in Bangalore earlier and then you came to Delhi and all that. Could you just take us through that?
I was born in Bangalore, and my initial kindergarten years were there, and then my parents moved to Delhi, and after that I've lived all my life in Delhi. I then went to school in Carmel Convent and did my graduation, post-graduation from Lady Shri Ram College, after which I did a stint of teaching. So after that I've been more or less Delhi based, and then I did my post-graduation, taught for a while. I went and enrolled myself in Jawaharlal Nehru University to do an MPhil, but at that point of time, I took a decision to move to the legal profession rather than go on with academics. I didn't complete the dissertation, so I left MPhil and came back into legal practice.
Right. So your father, Mr. O.P. Malhotra, very eminent senior counsel himself and author. How was it growing up as his daughter? I mean,
well, he was accustomed to working very, very long hours, and he wrote his book. And I remember very often at 3 and 4 in the morning he would wake up and work a good 14-15 hours at least on his book. So I certainly grew up in an atmosphere, in a background which was academic, and I think my father was very strict with four of us. There was no question of us, not doing well in our exams or, bunking classes. It was just not on. In fact, we didn't have a television in our house till we passed out of, school. Because he was very rigid. He thought that, these external factors, that time times were very different, and this was, over 25-30 years ago. And later on then people realized that, interaction, etc. is different. That time the kind of programs also on television were, basically films or something, So he thought we should not be deflected from the path. So he was very strict and rigid, and he ensured, and he did certainly push each one of us to study as much as we could. That he did. He was insistent, in fact, maybe, even dominating. And he was very, very keen that we were well educated. All of us, each one of us he pushed.
But considering the amount of time that, like you said, he spent at work, etc., how was it interactive? Did he get much time? Was he? You think a father was able to devote a lot of time to?
No.
The children?
No. It was just, I think, the atmosphere and the ambience.
Yes.
Like, you wake up early in the morning and you see that your father's been at his study for several hours. That does have an impact. That ambience is there of books and, reading and, and then he'd question us over dinner, about general current events and all. So that kind of interaction was there. Yeah, absolutely.
Right. And how many of you? You said there are 4.
We are 4 of us.
What do the others do?
My oldest sister did her masters in literature, and after that she settled down looking after her family. Right. My second sister did her masters, and she did her law. And law was absolutely done under dad's insistence. And my brother did his law. My father wasn't satisfied, sent him to Cambridge. And he said, you go and study there. Then he insisted that you do your barrister. He did his bar at law. Then he came and practiced in Bombay for 1 year. And then he said, no, you must get a master's degree in law. And then he sent him to Berkeley. And that time Berkeley was the second best university in the US after Harvard. And then he eventually took a decision to settle down there. I did my master's in political science and eventually went to law. And then I did, a course in company secretary from Law Institute, etc. So, he kept pushing us, all of us, to do as much as we could. He didn't like people, reading comics and Mills and Boons, so he was really
quite strict about it.
Yeah.
I just wanted to ask you, ma'am, how was it like being starting as a young woman lawyer in Supreme Court, like way back 20-25 years back? How was it?
It was very tough. It was very tough. It was tough not because I'm a woman, but I think it's a tough profession for men and women. They say law is a jealous mistress, and that is true. It requires a lot of undivided attention if you have to excel and do well. So it's a tough profession. It takes up a lot of your time and energy if you have to do well.
Do you have some interesting memories of your young days in Supreme Court, corridors, courts, courtrooms, briefing seniors, etc.?
Well, I think my maximum learning has been in interacting, briefing senior counsel, learning from the way they conduct their conferences, the way they study and get into a brief, and the way they went and presented it in court. So of course I think that was my major learning process. And today also, when you are free, don't just stand around in the corridors. Go and watch senior counsel present cases, and that's, I think, the major learning process. It's because in this profession people don't have the patience to sit and train juniors. You learn only by watching. So if you are attentive, you assimilate and imbibe more, and you learn how to present, and you watch the pulse of each court and what are the perceptions of a court and how to modulate your arguments accordingly. That's what you learn from seniors, how they do it, and it you assimilate it in the process.
Ma'am, you mentioned that as a young lawyer, some of your greatest inspirations were senior members of the bar. Could you talk us through some of them, and even members of the judiciary who continue to inspire you?
Well, some of the eminent seniors who have impacted me, one is Mr. Nariman, for the reason that I found him never superficial in the preparation of his briefs. He's always been extremely in-depth. He goes to the root of, the matter. And there are, issues which would not have even occurred to you while preparing the brief. But he has always been very incisive and very, very well prepared in his briefs. I remember one day, this was some years back when I was an advocate on record, a matter before the Constitution bench was shown the previous evening. So I called him up and I said, Mr. Nariman, we can't do it. We have to go and take an adjournment, and the state of Kerala has also said they're taking an adjournment. I said, we can't just go. So he told me on the phone, he said, that's not the way. He says, when a matter is reaching, you keep awake the whole night. We will go ready to argue the matter, and you will be in my chambers at 8 o'clock in the morning. We are not asking for any adjournment. We'll go prepared. So, these are things which you learn from seniors that, and in the morning, the Council for State of Kerala was asking for an adjournment. The court won't grant it, and then we had to start. So you see, you can't take an adjournment for granted. So these are things which you learn. Another thing which I learned from Gopal Subramaniam, this was almost when I entered the profession, he told me, he said, I met him and he said, never enter into a courtroom without reading your brief. Even if it's for mentioning a matter, don't go and address the court if you don't know, your brief. The judges will forgive you if you don't know the law, but they will not forgive you if you don't know the facts. So, this well-preparedness, this is things which you learn from various seniors. And then I saw, people like Mr. Jethmalani, Mr. Chidambaram, always very, very pleasant. Another seniors, Mr. Desai, extremely pleasant with the bench. They never get acrimonious with anyone. So, that you have to imbibe a good temper also. Because if you get acrimonious, I think you lose a lot in the profession. You lose it in terms of, like some seniors who've had an irascible temper, they lost out in their interactions with solicitors, in their interactions with the court. So you have to also maintain, a good temper to progress. It's a combination of qualities which you have to emulate. Apart from being bright or, jurisprudentially sound or hardworking, there are various other factors also, your court mannerisms, etc., which also have to be assimilated as you go along. And these things you evolve over a period of time. It doesn't come on day one,
Among the senior advocates, the way they address the court, have you seen any major changes that over the last, since you started in the profession and now, have you seen any major differences in the way the court is being addressed, in the way some methods of address are being entertained more than others, things like that?
I don't think anything very perceptibly. Only thing which I do find a difference is that earlier seniors used to refrain from mentioning matters before the courts. It was taboo. There was no written law. It was a convention that seniors would not mention. But now with urgent interim orders, with stakes so large and orders being passed on mentioning, seniors are dominating almost every area. And I feel that certain areas have to be left free even for the junior bar to grow. Otherwise, how do they grow? And secondly, I feel it is the responsibility also of the senior bar to train juniors, to take them into their, offices, chambers and train them, be generous in training them. Some seniors do it, some don't, but I think that's very essential as a part of the process of growth, because growth is, part of evolution. You don't start becoming successful. In litigation, I feel the more number of years you have, the more useful it is. And that's how you earn more. It's, it becomes more remunerative as you grow older.
Right. You started with Mr. Praveen Parikh's office. What was that experience like?
It was a very good experience. That was the time when I got the best platform to interact with all top seniors. Right. Because he had, when I joined him at the bar, I think he had the largest practice in the Supreme Court as a counsel on record. And he used to brief the top seniors. So I got a chance to brief Mr. Nariman the most that time. Then it was also Mr. Jethmalani. They were at that time at the top. Then Mr. Sorabji. So they were various seniors, and his was basically a counsel on records office. And the second greatest experience I got, for which I'm very grateful to him, that I think on every single day he used to entrust me with at least 3 or 4 mentioning matters.
Right.
And I must tell you this, that when he felt that I was mustering courage to address the court, I remember on one occasion in the court of the Chief Justice, when I was arguing a matter, he came and sat by my side, and that gave me a lot of support.
Correct. That someone who's your senior is sitting next to
Yeah.
you while you're addressing
Yeah.
the court.
Yeah.
That would have an impact even as far as the judges are concerned. one would imagine.
Absolutely, and it builds up your confidence level, because you see, the confidence level you have to address the Supreme Court has to be, it has to be also backed with, control over your brief on the law. You can't just, go and start addressing the court. And then there is a mannerism also which you have to learn and, imbibe in addressing the judges. So I learnt a lot in his chambers.
On the topic of judges that you admire even now,
One of the judges whom I have a great respect for was Chief Justice Venkatchalaya. I found him, he was very well informed, he had no biases, and he used to be open to listening to people. And the best thing about him was that he was equally responsive to junior members of the bar. And I was a junior member when I used to address him, and he was very responsive and kind. So he is one of the judges I remember with a lot of affection, and jurisprudentially extremely sound and very good with his law. So, he was encouraging to the junior bar. And that's what you remember, because that's how you grow. Because I feel for the growth of a junior lawyer, the judges play a huge role. They play a very, very important role. Because if they just brush you aside, then your self-esteem goes. And who'll entrust you with a second brief if the judges don't listen to you? And in those days seniors didn't mention, so I got a lot of opportunities to address the court for mentioning one matter or the other, so that helped.
At the time when you started off in the profession and when you were possibly a little unsure moving in, there must have been some errors you committed which taught you, oh, this is not the right way, I should hone my practice in a different direction. Any lessons from that? Any errors, anything that you've changed over time?
It's difficult to say any specific thing. I think you just keep evolving, growing, and self-correcting as you go along. But I can't remember anything very drastic or major which I can really narrate to you at this point of time. I don't think there was something which played such a major role really.
Right. But what was, say, your first major case? Something that you felt was instrumental in assuring you that there is a future in this profession for you and you can go ahead. Something where you felt your contribution was substantial, where you could take it forward.
Well, there was one. I think I was almost about 2 or 3 years at the bar, and I got an opportunity. Mr. Parekh had wanted me to prepare a case of dental medical students, and unfortunately, just a day or two before, he had a very, very serious accident. So I got an opportunity to address the Constitution bench. And what my advice to the junior bar is that you must always be in a state of preparedness. And there are a lot of opportunities which come to you by default, and don't miss those out. If you are not prepared and you're just expecting a senior to come and you've done some superficial reading, you lose out all these chances. So especially in the Supreme Court, you grow by these defaults. And if you are not ready yourself, then you lose out.
Right. As far as preparing for a case is concerned, normally considering the Supreme Court divide between miscellaneous cases and final hearings, for a miscellaneous case, which is just for admission, how do you prepare? What is the kind of time you spend on it, and what do you think are the important things a person should look at, especially when you have interns and young members of the bar starting off? They find it somewhat overwhelming when they're dealing with 300-page briefs, and they have to quickly prepare a note, say, for a senior advocate or someone who's going to address the matter. How would you advise them to go about it? What is the approach you take?
The approach which I take is, I don't feel comfortable to go into any courtroom without reading the brief from cover to cover. That's been my habit from the beginning. And I feel it has held me in good stead. And I would always advise juniors not to get carried away by, some of the top seniors, because they have learnt the art of, getting at the jugular vein in a much shorter period. But it takes time to develop that art. And I feel you should read your brief from cover to cover. and prepare first and foremost a list of dates. I think that's imperative. Then do your research and then formulate the, look at the impugned judgment and see how you meet it. I feel that is the most systematic way of doing it. One shouldn't, just go to the impugned judgment and start preparing. One is you must marshal the facts thoroughly. After you marshal the facts, do your research and then see where the lacuna and the fallacies are in the High Court judgment so that you can show it to the court.
Ma'am, remaining on the topic of the profession itself, what do you think the role of the professional associations in the legal profession are in an ideal situation?
In an ideal situation, not the present situation. In an ideal situation, I feel the bar associations can play an extremely important role to represent the interests of various groups, etc. The bar has various segments. They have women lawyers, they have junior counsel, the various segments of the bar. And I feel it can play a very, very important role in making representations even to the judiciary, like sometimes they don't know what's happening on this side. So, to make representations and make it work more harmoniously, like for instance, Advocates on Record had a big issue about mentioning, being in the middle of the day, there being no designated time, they were in different courts, they'd missed their matters. So, I'm just giving a small example. So, then the Bar Association, the president, secretary went to the chief, told them, please have a specific time when it's, possible for the advocates to attend to their cases. So, similar things can be done. Then, have benches which address specialized cases, groups of cases for disposal. So, various interactions happen to represent, interests of the bar, not only at a personal level, even at the professional level, to help even clear up arrears. The bar plays a huge role. So the bar associations, where they are, constituted from eminent members of the bar and who truly represent the bar, can play a very effective role. Even, maintaining the infrastructure, the libraries, all that.
With the regulatory body, the Bar Council, Professor Madhav Menon has written an article in the Hindu a few months ago saying that we should probably abolish the Bar Council, partly because of how inactive it's become, partly because it's proactive in the wrong direction. There seems to be a tendency for it to be an extremely politicized body today. The Bar Council has certain responsibilities with reference to those practicing before the Supreme Courts and the High Courts, and that's been its mandate. Now, there has been a belief, especially in the background over the past few months, of misconduct by lawyers, some of them being caught on camera in sting operations, some of them going on strike and bringing the entire legal system of a certain state to a halt. In those kind of backgrounds, what do you think ideally the Bar Council should be doing?
Bar Council has not played its role which was envisaged for it. The Bar Council today is so highly politicized, and I feel even in the way they conduct cases, it's highly unsatisfactory. In fact, recently, one of my solicitor friends from Bombay, there was a matter going on before the Bar Council for 25 years, which we've just got wrapped up. And it just went completely by default. The State Council didn't hear it. Then there is a provision that if the State Commission doesn't dispose it off within a period of time, goes to the Bar Council, went to the apex body. Apex body went and passed some completely peremptory orders, and that also after huge time lag of 9-10 months, forgot all the facts. Eventually we went to Supreme Court, got it set aside, and we've now concluded the matter. It took 25 years. So certainly the Bar Council is not playing the role, which was envisaged for it at all.
Right. And do you envisage some method of cleaning that up or changing the system in any way? Do you think that's possible?
Well, then the mode of constituting the Bar Council will have to change. Today it's completely politicized. And people who are serious professionals and jurists, etc., don't get involved with these elections at all.
Right.
So that is why they are really not reflective of the bar in the true sense.
Right. The National Knowledge Commission seems to feel that the Bar Council doesn't have within its mandate the monitoring and regulation of legal education at all in this country. Because even as far as its own constitution is concerned, it's supposed to only deal with the practice of advocates before the courts. So if the Bar Council is removed completely from regulating legal education in this country, do you think the lot of legal education could improve? Because many of the institutes, etc., are very, very dependent on what the Bar Council says and how they react to certain situations, what standards they set. Do you think that in any way will impact?
I think, frankly speaking, it would be better for the the colleges, law colleges themselves, to take a proactive role in improving the level of legal education, because I think this would be, in a vast country like India,
Yes.
I don't see that really happening, and them controlling the level of legal education. I think it will have to be done more at the level of the colleges themselves.
Right.
Ma'am, about the judiciary, what is your opinion on the skill levels currently at the judiciary, and what additional skills need to be imparted at all levels of the judiciary today?
I think one of the skills which is very important, in my opinion, judiciary is very personality oriented, and I think they have to be sensitized to the junior bar. Some women feel, although I personally haven't had that experience, some women also feel that there is a level of gender bias, especially where women who argue is concerned, not women who are advocates on record or solicitors, because they don't really address the court, so they don't feel the brunt of it. So I feel that the judiciary needs to be sensitized on these issues, because by and large, I feel the junior bar doesn't get received so well. They don't get adequate opportunities for growth and addressing the court, and a junior evolves only if they get more and more chances to address the court and to deal with cases, and that comes only if the judiciary is also sensitized, because I feel they play the most important role in building up the junior bar. Because if a junior gets lambasted, you hit out at his self-esteem. And his confidence, you undermine his confidence. So it's for the judges also to really train the junior bar. They have a role also.
There have been suggestions in the recent past about possibly having some sort of entrance exam or some basic cutoff before an advocate can practice before the Supreme Court, because it's an appellate body, and like everybody says, it's correct because it's final, not final because it's correct. Now, because of the onerous responsibility on a advocate practicing before the Supreme Court, do you agree that there should be some sort of a cutoff like that?
Not a cutoff. What I do sincerely feel that one should never start one's practice in the Supreme Court. I feel it's very essential that a junior lawyer, when they enter into the profession, they want to go in for litigation, they must spend at least 3 years in the trial court, and after that maybe 2 or 3 years in the High Court, and then move up to Supreme Court. For the reason that an initial entrant doesn't even know how to address the court, what to say, you see. Like I remember there was several years back, a junior lawyer went in and said to the bench, "My lord, this matter stands adjourned." Now they were actually going to seek an adjournment. He said, "Since you passed the order, what do you want me to do? Ratify your decision." So very often the juniors don't even know what to say to the court. And I feel, grounding in basic, like the law of evidence, code of civil procedure, all that comes only with proper practice. I feel it's essential to start at the trial court level, work for 3 years, and then move upward.
Now, a large number of graduates across the country, severely high percentage of them, choose to join, the commercial field, commercial transactional work with law firms or with companies as in-house counsel. Some of the reasons why they do this, apart from their own interest in the commercial area of law, is partly because they don't see the kind of security that they would otherwise get if they came into litigation. Both as far as money and income is concerned, as well as the security that in the future I will get more clientele, I can stand on my own 2 feet, etc. Now, are there any things you can say which could possibly demystify litigation for them, give them an idea why it may not be that bad an option?
I think today the situation has changed drastically since when I entered the profession, which was about 26 years ago. That time juniors really were paid a very, very niggardly amount. It
Or
was
not paid at all?
Yeah, I was for 3.5 years of practice, when I left and started my own practice, I was being paid some 2,000 rupees, which included also the fuel expenses and the transport charges to go to senior counsel. So it was actually, we were in the minus.
Yes.
We had nothing. We had nothing left. So, that is where your background came in, that if you could afford that, then only you went into litigation, because the gestation period was in fact very, very long and slow.
Right.
Today, I feel that the juniors are paid far better. Like when they enter into the profession, if they are from good law schools, etc., they are certainly paid a far better amount, and I don't think seniors also resent paying them. The stakes are large, they earn far more. So I think juniors have a better start now than during my times. And I think if you join a good chamber, and you get opportunities of getting onto some panels and all, that helps for a person to sustain themselves.
Right. Now, someone who is confident about articulating their thoughts, understanding legal principles, applying it to given fact situations, someone like that, if that person wished to come directly to the Supreme Court and felt that they have the possible confidence to address courts on their own, one of the factors that would play in that person's mind would be the fact that possibly in the Supreme Court I might get paid better than if I started off in the trial court or the High Court. And that's one of the reasons that you've seen the junior bar here expand to a great degree over the last few years.
Correct, that's right.
Right. Now, if that was so, would you still hold by what you said, that they should start with the trial courts and move up?
Why I said the trial court was not on account of the money part. It was the grounding.
Right.
In basic principles, applications, and basic drafting skills and all, which you learn much better in the trial court. Like, evidence and all. There's so many, like the basic concepts I feel get clarified much better. And you see a trial in, otherwise you really never get an opportunity, during your later years to ever get that experience and knowledge again.
Right.
I feel that basic good grounding of 2-3 years does help. Because profession is not only articulation, it's a good grounding, and learning the skills of addressing the court, and then you're more confident in addressing a court which is at the district level than the Supreme Court. You feel too overwhelmed, and the judges from all over, and they are not so responsive to the junior bar, so it can be very undermining in the beginning.
Right. Now, when you started off in the profession, you obviously didn't have the options that youngsters have today of a very lucrative commercial firm option. Now, suppose we were to wind the clock back and somebody tells you that, apart from litigation, you have this option whether you could get $1 lakh a month and lots of perquisites and things like that. Would you take that? And if not, why not?
I don't think I would take it. I have loved litigation because I find it's really quite exciting and thrilling. There's a new case, is a new experience. That work in the corporate sector gets very repetitive after a while,
right.
and it gets very monotonous. In the courts, they're a buzz with what's happening
right.
in the realities of life, and I think each case is a new experience, and you thoroughly enjoy it.
You feel a certain flexibility about your day at work also? If you in litigation, do you think you could take off if a matter is not reaching and go meet a friend or things like that, which may not be?
To tell you the truth, I don't think that flexibility is there.
No,
for
right.
the reason that if a matter is on the board, you never know when the board crashes.
Right.
So it is difficult actually to take off.
Right.
You have to be available.
Throughout.
And especially if you're a counsel, then you owe it to the client to
Right.
be available in the court during working hours.
Right.
During the middle of the, you can be in the court precincts, you can be in the library or in your chamber. That flexibility is there. You don't need to be riveted in the courtroom the whole day.
Right.
But I think you need to be available to be a you owe that
Right.
responsibility to the counsel on record and to the client.
Right. Now, the Supreme Court has this counsel of record system, which is distinct from the other advocates who practice before the court. Could you just outline exactly what the AOR system in the Supreme Court is as against counsel practice? Because many of the viewers might want to know what that is about.
Well, a person becomes an advocate on record after 4 years of practice, and then you have to take an exam which is conducted by the Supreme Court itself. Most of the question papers are framed by the judges or by eminent seniors who correct the papers also. and after you qualify in that examination, that you can file matters in the court.
Only an advocate on record
Only
can do
an
that.
advocate on record can file matters in Supreme Court, not a non-advocate on record. So they've institutionalized the system, and the advocate on record is the person who is responsible to the court for the pleadings and for various things, or engagement of a counsel. A counsel also gets the right to appear and address the court only if he is so engaged by the advocate on record. So they've institutionalized the system, and they wanted people with at least 5 years of practice before they came to the court and started filing, to prevent all and sundry from filing frivolous petitions, etc. So this entire system was started, and I think it's a good system, and it teaches you a lot. You learn how to interact with the client, you learn how to draft a matter, how to address the court in small matters, how to get matters listed. So the entire procedure you learn.
And this helps you in evolving strategy for your clients as well.
Tremendously, because you had interaction with the client, you know exactly what his problems are, and that helps you understand the case and how to present it, and what are the pitfalls and what are the strong points and how to present it. Surely it helps.
Right. But logically, if an advocate on record who files the matter has to go through some kind of an examination where they will test you on certain areas of law, does it not also make sense that anybody else who is going to practice before the court have some kind of an equal examination or test by which they would be qualified to represent before the court?
Well, it's difficult for every lawyer to go through that test, in the sense there are seniors who are designated from different courts and all.
Right.
If that test would be applied, it would be, I haven't actually given a thought to it, but that means every senior counsel and every non-senior counsel who addresses the court should have qualified in that test.
Right.
I think more than that, maybe it's the experience which would be better.
Right, which makes the difference.
Yeah.
Ma'am, on the subject of clients, what methods are prevalent today as far as billing clients is concerned, and what method do you prefer in doing that?
I think the method which I'm following is just a straightforward, it's done chronologically, date-wise, and this thing, and that's how, we bill. There's no this thing. I mean, see, it's for solicitors firms that the billing really is different. For counsel, once you become a senior counsel, then you just bill on the daily appearances that you make, and that's how it is followed.
As far as a junior lawyer is concerned, suppose he joins the profession, how does he go about getting clients, for example, or generating work to ensure that on some day he could step free of the office he's joined and go out on his own? How would you advise someone to?
Well, I think first and foremost for a junior counsel, it's very essential if they can get onto a panel.
Right.
Because panel work gives you the exposure and it gives you the confidence.
These are panels of?
State governments, corporations, there are so many of them.
Right.
So I think the most important thing is to get onto the panels.
Won't that be politicized, ma'am? I mean, heavily?
It is politicized, but then if you have a contact and you can get onto it, I think it helps a lot.
Right.
It helps a lot.
Right.
I remember just after I had become an advocate on record, by default I became the counsel on the standing counsel for state of Haryana.
Right.
And I was the standing counsel for 5 years, from 1991 to 1996. And I think that was the period when I learnt the most. I just became, the counsel on record by default because the government changed, and I had been appearing for the chief minister in a matter, who knew me as the counsel on record, and he asked me to, become the standing counsel. That helped tremendously, because I was on an average on any Monday doing about 15 matters, definitely 15 matters on a Monday, and a lesser number on Friday because a lesser number of SLPs listed, and then some, fair amount of final hearings. So everything wasn't really senior counsel oriented. So that helped a lot. It helped me tremendously, gaining confidence, reading a brief, swiftness, in reading the brief and all. It helped a lot because the volumes of work.
Ma'am, I would like to ask you about this, the whole internship system that the law school, majority of the law schools have. So what has been your experience when dealing with the interns, and would you have some suggestions for the law schools to, incorporate, and at what level?
I think internships should start a minimum 3 years after you're into law school, because one must not forget that law colleges today are a combination. It's 5 years, which means it subsumes also the graduation period. So they cut short 1 year and make it 5. So the first 3 years, I feel you need that grounding. Children are too immature to really learn when they come to the offices of solicitors or counsel, or just float around the court. They're just getting, seeing things without really understanding. After 3 years, when you come into the 4th and 5th year, you learn more. And I think it's essential that a module is made, that let a person draft something, or a judgment which they've heard, make a note on it. So a module should be prepared, and they should be tested out, that what have you done during this internship, and come and give a resume and mark them on it. Otherwise everyone just mechanically gives them certificates and they go back, and that doesn't help. To learn, actually you should show it that you've drafted something. So test them on their drafting skills, or a judgment case you've been listening to in the court, whatever experiences, to translate it and show it on paper.
Another thing just connected to this, what would you, for example, once a fresh law graduates, once they graduate, what would you suggest them, as in how should they go about picking up an office or a senior or a firm? What should be the criterias and things that they should be looking at? Because in majority of the cases, they already have 4 or 5 internships by the time they finish their law.
My suggestion is certainly, which I said a little while earlier, that they must go to the trial court and practice for 2 to 3 years at least before they come into the bigger firms and all. There's so many things, like you immediately join a corporate office. Now you need to you start vetting agreements. You don't know a thing about it. You must have your basics in place, like even a bank guarantee. You don't know the basic law, and what are the important points which should be included and all. So I feel it's very essential to go through 3 years in the trial courts before you get into.
But the biggest problem with that, at least from the student's point of view, is that trial court lawyers are notorious for not paying you, or if they pay you a paltry amount, and their justification for that is that you are learning from me, so in fact you should be paying me. So that's one of the major issues why students are very, very discouraged by the idea of joining trial courts. I mean, even in our own court here in Delhi, in the High Courts or Supreme Court, you would have noticed that most of your peers, senior advocates, etc., are possibly not very generous paymasters. They are willing to forego a bit of quality so that they can cut down on the cost of affording juniors. So I mean, do you feel that there is a big concern as far as the payment that freshers are likely to get?
Well, I feel that today times have changed a lot. People have moved on, and if you want meritorious juniors in your office, then you have to pay them as per at least the beginning of what corporate people pay. Otherwise, you lose out talent. And I feel if you want talent in your office, you have to pay. I think times have changed. I'm telling you, for 3.5 years I was just on 2,000 rupees.
Right.
So, and today I think freshers do start at a much better amount, and then to retain good juniors whom you've trained, only if you pay them something more on briefs, etc., is it an incentive for them to stay on. Otherwise, juniors also move on.
Right.
And I think that also is people are realizing that. Senior counsel, solicitors firms are realizing that to retain good juniors, you have to pay them more,
Right.
make them grow.
Another concern I think many young lawyers have is that litigation has become a profession where if you have family in the profession, you have a great chance to get ahead because there is a cushion, a platform that starts you off. And if you don't, or if you don't have a very good godfather in this system, then it's extremely difficult. Now, you come from a family where your father was a senior advocate. Did that really help? Did he really give you a push up, or did you have to fend for yourself? And what do you think generally about family in the law?
Well, let me tell you, start with my own experience. I have struggled very hard. I don't think even 1% of my clients have come from my father, for the reason that he was a senior counsel. I started as a counsel on record, so he didn't have direct clients as such whom he could refer to me. I had to struggle very hard. I had to, nurture my own contacts and, grow slowly. And it's actually brief by brief that I grew. Actually brief by brief. So it's not as if, I inherited any practice as such. And I think, people who really made it to the top haven't made it, where they've inherited a practice. I think you have to work very hard to prove yourself. Whether it's a solicitor, even what I feel is that a relationship can give you an introduction, but to sustain the client, you need to be meritorious. You need to, otherwise you won't be able to retain the client. And today I think it's very competitive. You can't just, keep clients because you've got them from your parents or your, family.
Right.
You have to work very, very hard to retain them.
So you're saying that maybe in the initial years, it may make a little bit of a difference. But eventually, if your own merit doesn't satisfy the
Absolutely.
client, it's not going to be based on
Absolutely.
you.
Today, the clients, the corporate clientele especially, are extremely discerning. And they will not stay with someone's son or daughter if, they're not meritorious or they're not, responding to them in time.
Ma'am, on the subject of senior advocates, what are the responsibilities of a senior advocate, and do you see these responsibilities being practiced today?
Well, I think one of the main responsibilities is to develop the junior bar. I feel the seniors must take at least, 5 to 6 juniors and train them. You train them, you pay them so that they grow. That is one part. Second is, I think the juniors also emulate the seniors. And when a senior takes up a matter, and there's something which I saw Mr. Parasaran doing, when he'd take up a final hearing matter, he would never leave the court. He would not flit from court to court because you are answerable to the client and to the court. And secondly, I feel you lose on the continuity of a matter, because very often I've seen people losing matters because they flitted in and out of the court. The continuity is lost. I feel you owe that to the matter and to the court, that once you take up a matter and it's part of to be there throughout. That's something, and juniors emulate that from the seniors. They also feel they can, walk in and walk out, which I don't think is a good practice. So these are, I feel, some of the important things which, and third is, I think the seniors also have a role to protect the junior bar. Sometimes judges, get into a rage over a junior not performing in the way they think he should have done, or I feel the senior bar should be more protective also. To teach them, guide them rather than lambaste and undermine them.
You're on the executive council of the Gujarat National Law University. As far as legal education in this country is concerned, we know that it's come quite far with the setting up of the 5-year law schools, etc. But are there any issues that you think still need to be addressed as far as legal education in this country is concerned? Because even now we know that many students across many universities in this country, even in the 5-year ones, have very strong grievances regarding how their institutions are run, regarding the quality of the faculty, regarding the curriculum, regarding random realignment of exam schedules and projects, and some colleges even fine you if you take part in a moot court competition on behalf of the college. So
Really?
yeah, actually, that's one of the
Fine you?
They have fined some students for taking part in a moot court competition. So what are the things you think need to be improved, and how does one go about doing that, especially with reference to inputs from academics are concerned?
I think one is that in these law colleges, what's essential is that persons of eminence, like jurists, top seniors who specialize in certain branches of law, to call them for guest lectures during when it's court vacations, because busy senior counsel will not be able to go when the courts are on. So to try and schedule maybe a 3-week course, or if that's too much, even a 1-week course, which is useful. This can also be done through videographing. And then even eminent faculty members, if they're not rigidly bound down to one institution, and they are also invited by other colleges. Third is, I think we need to also develop a module for internships. Today I see students just come and float around and go back. they really don't learn too much. A proper module needs to be done, prepared for them so that they're trained when they come into offices of senior counsel, solicitors and all before they go back. So I think these are things which will help, good faculty. And I remember National Law School at one time used to call eminent seniors, they used to call Mr. Jetmalani, Mr. Nariman, all of them to come and deliver lectures for a week, 10 days. I think those proactive steps also need to be taken. It helps a lot.
Ma'am, one of the major problems being faced by, or one of the major criticisms of legal education today is that the faculty does not publish nearly enough scholarly output. What do you think can be done to remedy the situation if you think there is a problem with this?
I think students also have to be encouraged, to write articles, and you send them for overseas, that interaction also helps. Like Gopal was saying about moot courts, etc. So that exposure, if they get, those opportunities are made available to students, they're told about it. So it's really the faculty has to be very proactive in making the students grow. And then mark them on, the papers they write, so that, if it's very well researched, etc., it helps. It encourages them. And then help them to publish them in, some journals, etc.
I just wanted to ask you one thing. For example, earlier the law colleges used to be the center for political activity, political as in I'm using it in a very positive sense, and idealism, discussion. And today it's more job oriented. People are, right from the first day you enter college, all that you are targeting is, getting into a institute or getting a job with a good pay package, etc. So do you think that there is a need to, just tell them just to relax and just be a bit laid back and think a little about the society around them rather than just being focused on the job? I mean, are we making law as an education very, very, it's like an MBA or that sort of thing, or
orientation? Entire orientation has changed. In fact, today people view law to be one of the most lucrative professions.
Right.
And that's why there has been such an influx of people into this profession, which was earlier considered to be a discarded profession. About 25, 28 years ago, people never looked to law at all.
Right.
It was the civil services, after that was medicine, and law was
engineering.
law was just an extra degree people thought of getting. But today it's considered to be one of the most lucrative professions, especially with corporate practice, paying big pay packages to junior lawyers and all.
Right.
So that orientation has changed, and I think the pressures of life have also, made people, the juniors, children also today have become far more competitive as to how they want to have a better life.
Right. Taking up from what Sunita said, I mean, at the time of independence, I think a large number of our leaders were all lawyers, like Gandhi and Nehru, etc. And then again, at the next point of turmoil, which is the emergency, we saw the growth of leaders who were lawyers, like Mr. Jaitley, etc. And it has been, for many reasons, lawyers who have been at the forefront of political movements and socially minded ventures, etc., including Mr. M.C. Mehta and his environmental litigation, etc. Do you think that the system of education now has become, like Sunita was mentioning, so commercial or so oriented towards a career that we have lost that sense of empathy and idealism with a larger social goal or ideal? Do you think that could be corrected in some way?
I think that's true, and I think it's really responsive of the times we live in.
Right.
That time it was the freedom struggle, those things dominated the entire thinking. Now, with globalization, everything's become so competitive that it's percolated into every aspect of life, and that's really taken over. So that idealism seems to have really vanished.
Right.
And it's really more, how much who's making. In fact, one of my juniors at one time told me, she said, every time we meet our friends, then, the question each one asks the others, are you still in the same office or have you moved on? So, people feel that it's important for them to be on the fast track in making money and, succeeding rather than picking up values. And
Ma'am, you're also co-author of the second edition of the commentary on Arbitration and Conciliation, which you've co-written with your father. What was that experience, writing on such an overwhelmingly large area of law, which has developed so much over the last dozen years?
It's a very interesting experience. Requires, it is a bit tedious. You need to be reading, the prints and adding on to all the latest judgments which come in. So it's a very tedious kind of work, but I enjoy doing it because you can really contribute to the law. You can give your own thoughts, and the way the judgments are coming. I think it's a very interesting experience.
What do you think is the aim of arbitration essentially?
Is a speedy resolution through a transparent process and which finally resolves disputes. The problem which I find today is not in getting the award. It is the enforcement part which has really run into trouble in our country. That is where I feel is the major issue. It's not in getting an arbitrator appointed or getting the award done. That it takes place in a couple of years and you're through with it. But once you have the award, it almost is rendered like a piece of paper in your hand, because enforcement has become a big problem, and particularly in view of the two judgments of the Supreme Court wherein they have said that once objections are filed, the entire award gets suspended. So with the enforcement of the award having become a problem, arbitration is losing its meaning. That is where I feel the major problem in arbitration arises in our country.
Today, many commercial outfits in the country, especially commercial law firms, are very concerned about how the courts are interpreting the Arbitration Act. There seems to be a tendency that almost at every stage, appointment of arbitrator, asking for an interim order, even of the setting aside of the award, etc., everything goes all the way up to the Supreme Court, and matters get stayed and it drags on for years. Now, are there any important judgments you think which possibly the courts ought to revisit, reconsider at some point?
There are quite a few judgments which require to be revisited. In fact, they have been referred to larger benches. But I think the main problem today is that there is too much of judicial intervention at every single stage. And for that, I think it's necessary that all judges are given some training courses, particularly with respect to international arbitrations, because domestic arbitrations apart, if we want commerce to grow in our country and people to feel, the international community to feel that we have a credible system, then we need to adapt ourselves to the international needs. Otherwise, what will happen is, and I think it is happening now, that a lot of people in the international commercial community want to move to places like Singapore or to London for resolving their arbitration disputes rather than getting it resolved in India, because they feel the minute you come to India, some court intervention will, it'll just make the matter pen for years and years, and which has been happening. For instance, the latest judgment of, not latest, it was in 2008, I think January or March it came, Global Ventures, wherein they have gone and said that section 34, which is setting aside of an award, is also applicable to part 2, which is, I think, a disaster. Something which the statute doesn't provide, of setting aside a foreign award, is now being made available by this judgment.
What is the implication of something like that? Could you give us an example?
The implication is that under Part 2 of the Arbitration Conciliation Act, which is applicable to New York Convention awards, there is no power in the Indian courts to set aside a foreign award which has been validly passed. Now, by saying that Section 34, which is under Part 1 of the Act, which is applicable to domestic awards, that power is also applicable to Part 2, which means that the courts have the right to even set aside a foreign award. And I think that is completely unpalatable.
So in an international commercial agreement, then, you can have the foreign party who loses the award coming here and setting aside that award.
Absolutely,
in these courts.
Absolutely. Except if they have, now what a lot of firms have been doing, which I've been speaking to a lot of lawyers at international conferences, they've been saying that we have been excluding specific sections of the Arbitration Act from being applicable to their agreements. But that's not a satisfactory thing. I think we need, frankly speaking, I feel there has to be a separate act for foreign arbitrations compared with domestic, because they really work in completely different arenas. And what happens is that when they are in the same act, there's a part 1, part 2, the courts tend to fall into the mischief of comparing and coming to all kinds of misconceived analogies which are actually not applicable, because domestic awards work in a completely different domain than international awards, and the delay in the court in enforcement is really a serious issue which I feel requires to be attended to immediately. Like, there are 2004 awards where the objections were filed which are now being heard in the Delhi High Court. So it's too long drawn, and the entire purpose was expedition, transparency, swiftness, economy. All these factors, I think, are now being defeated by this long drawn method. There has to be a specialized bench which is hearing objections, and hearing objections within the parameters of the act, and not like an appeal.
Right.
The pitfall that they fall into is that they try and they treat it like a first appeal and go into every aspect of it, and that is not what is the scope of the objections.
You're a member of the National Legal Services Authority. Now, that's very, very important today when it comes to indigent people who are not able to afford legal recourse, etc. Now, what are the problems that the Legal Services Authority perceives in the implementation of legal aid in this country?
Well, there first of all is lack of awareness, and that is what they're trying to address. They're trying to inform people, through the presidents of the Bar Association, etc., sending information in the vernacular language to educate people and tell them the availability of this, of getting free legal advice and from reasonably competent lawyers. So that's one of the projects which they've undertaken. Then they are also going into various other social projects. In fact, one of the projects which they had recently done in 2008 was that they had seminars all over the country with respect to the responsibilities of the press in reporting matters which are sub judice. So then, and another project they worked on was the National Rural Employment Guarantee Scheme, which most people were unaware of. So they had held seminars all over, and they called people from the taluks, the districts, to educate them about the availability. In fact, they were completely unaware of these schemes. So they are taking up various projects. In fact, now one of the issues which has been mooted is with respect to construction workers in the construction industry, wherein a fund is being proposed to be created under the Act. It's a statutory enactment, but the issue is not only actually the creation of the fund; it's disbursement of the amounts. In fact, that is one of the issues which I've been addressing. That it's not the creation of the fund. You charge a 1% cess on the builder, but how do you disburse it? Because these are all casual workers who, once they finish one site, go on to another and to a third, so the employers keep changing. So at the end of the day, how do you disburse these amounts to them? Like it happened with respect to Provident Fund. When they made it mandatory, the Comptroller and Auditor General came out with a report in 2003 that with respect to Provident Fund, there was an amount of over 9 crore lying unclaimed. Because these people they are not aware of it, their monies get cut for Provident Fund, they don't get the benefit of it. So that is something you have to translate it into a reality for it to be meaningful for them, having these socially beneficial schemes.
Ma'am, for persons who can't afford access to justice, how is legal aid in India currently funded, and what reforms do you propose be made to the method of funding legal aid?
Well, and so far, I'm not aware of the High Court and the lower courts, but in the Supreme Court, I think they have a huge fund. Insofar as the national body is concerned, government has given a huge fund, and there is also a committee which has been constituted called the Middle Income Level Committee. They have a lot of funds. The problem is that you have to ensure that the cases are given to responsible lawyers who do it in time. Most often we find that these legal aid committees, the cases are delayed tremendously by a year or two, so the matter goes by default on account of the limitation aspect, and you don't even come to the merits of it. So I think what's most critical is to have a responsible panel of lawyers who will attend to it diligently and conscientiously. That's what is, I think, more important. And second is, of course, awareness. And I had in fact suggested at Bangalore just last week, where we had an all India meet, that I think it needs to also be done through the media, to inform them that this facility is available. Most people are not aware of it at all. So the cases were not coming. The number of cases which came were very, very small, and eventually we were taking a decision to return the funds to the government.
Ma'am, when you said that to have a panel of very, very diligent lawyers, what do you suggest? How should we go about it? Because at whatever our experience is, the legal aid lawyers always cut a very sorry figure before the court. They are not well equipped, they are not given briefs at proper time, they are not well paid. So there is no, and those who have a very good practice, the lawyers who are good in their job, they will never have the time to do this kind of work. So how do we go about doing it?
Well, I think the panels are now being formed by the lawyers and eminent senior counsel, and these panels which are being formed, they also, I think, have to ensure the contact with the client. Otherwise you don't know what the client wants, and I think long distance, it doesn't work by just sending a letter in the papers. You need to have an interaction with the client to understand the actual problem, so that you can thereafter project and articulate his case in the court. It can't happen long distance. I feel for the legal aid societies also, they must at least fund, if a person is really in indigent circumstances, they should at least fund his visit once by train to Delhi, so that he can come and instruct the lawyer properly. And third is, you must have a responsible panel of lawyers who will also follow it up properly. Most of them, once it's a legal aid matter, just don't bother, and the matters are filed after a year, 2 years, so the entire case loses its effect.
Right. In the sense, building faith of people that somebody who has taken your case through legal aid is going to do justice to your case, that kind of faith, I think that how would you suggest that?
I think it'll come over a period of time when you have lawyers who are tending to it properly, keeping the party informed. Most of the time party is oblivious of what's happening, and they are sitting in some remote place from away from the court, so they don't even know what's happening in their matter. They're not being kept informed. So it's important that they're kept informed. They have one interaction at least with the lawyer who will present their case, so that it's done properly.
Thank you, ma'am, for this wonderful opportunity. The three of us learned a lot today, and I hope our viewers did as well.
Let your verdict give us the answer.